Hi, everybody. Welcome. Again, we haven't had a chance to introduce ourselves, so for those of you that don't know me, my name is Professor Medina. I teach at Madder Lakes Academy, so all of you guys should be Madder Lake students taking this Doral College dual enrollment business class. I want to actually post a lecture video every week, kind of explaining the topic for what we're going to be covering that week. I did not do that last week. I didn't want to overwhelm you. I know that many of you were taking for the first time different dual enrollment courses. So I actually want to teach this lecture for both week 1 and week 2. It also is week 2 is pretty easy, so I'm not really worried about it. So let's get to it. And if you have any questions, feel free to email me at either my Doral email, which is what's listed in the syllabus, or at my Madder Lakes email, which I also know that many of you have access to through the Madder Lakes website. So I'm going to begin sharing screen. And let's begin. So if you notice, the first chapter, what they're talking about is an intro to law topic, an intro law chapter. And if you've taken me for law studies before, a lot of the same material that you saw in this chapter should have seemed familiar, should have seemed something that you could recognize. Now, it's interesting, it's important to actually keep in mind what the purpose of law is and why we have laws. And different sources cite law differently, or different sources have a different definition for what law is. This business law textbook that we're using defines law as the system of rules which a particular nation or community recognizes as regulating the actions of its members and which it may enforce by the imposition of penalties. So if we had to define or kind of break down the elements of what that definition means, you're looking at a geographic boundary. So this textbook mentions a nation or a community, so it can be a city, a town, a state, a country, a province. If you're in other parts of the world, they have, instead of states, many times they call them provinces. A town, a city, a geographic area that members of the community have set as being a legit region for government to exist. And this region, whether it's a country, a city, a state, whatever, is trying to restrict or regulate behaviors, actions by members that are within that region. The last requirement for law to exist is that the way that they try to restrict or regulate those behaviors are through consequences or through the imposition of penalties. So if we have to break it down, 3 criteria for a law to exist, right? A geographic region that is recognized to have a government, that has an actual government. That's 1. Number 2, an effort to regulate behaviors or actions. So we're trying to control certain behaviors. And number 3, the means through which we try to control these behaviors are through consequences. So if you commit the crime of murder and there is a 20-year penalty for the first time that you commit that crime, you have a particular region that has defined murder in a particular way. They're trying to restrict the behavior of killing other people, and the consequences for you not following that restriction or that regulation is a 20-year punishment, right? So that's what a law is. Now, different textbooks, again, also define the purposes for law differently. Okay, why do we have laws? This book here mentions that law exists to keep the peace, to maintain the status quo, preserve individual rights, protect minorities, promote social justice, and provide for orderly change. Now, if we're being honest, sometimes these purposes vary and different people have different opinions on the legitimacy of these purposes. So maintaining the status quo isn't a purpose that we would normally associate in the United States as being one of the purposes of law. Keeping the peace is, though. Preserving individual rights is. Protecting minorities is. Other textbooks mention respecting the will of the majority. So all of these are different purposes that we can encounter for why we have law. This textbook mentions the 6 that you've seen there, but there are others that other textbooks provide as well. And they mention that while perhaps some of the purposes of law are met with certain types of government, by their very nature, specifically authoritarian governments, they may be unable to meet other purposes of government. So, in other words, perhaps China has the ability to maintain the peace within its borders, right? There's not a lot of crime many times in a country like China. There's not a lot of murder in countries like China. Why? Well, because the citizens are terrified of their government. So while they are able to maintain the status quo and keep the individual peace, they don't care at all for preserving individual rights or promoting social justice. They really don't care about those things. Um, so if you look at colonial times, maybe they did a lot of these other criteria. They kept the peace. They may have preserved individual rights for many, but they didn't care about protecting minorities, right? So each type of government at different moments in history has struggled perhaps with fulfilling the different purposes of law, and government's never going to be perfect. So there's never going to be a situation where a government fulfills each purpose of government equally and perfectly. Uh, so a lot of these problems you're going to encounter with countries that have multiple different nationalities within its boundaries. Africa is known for this, but before Africa, Europe also used to struggle with this a lot. And China and Asia also struggles with this a lot, where you encounter situations where, for example, the textbook mentions Rwanda, where the Hutus and the Tutsis had an issue with each other, and there were different nationalities, there were different groups that were under one country, and the majority committed genocide against the minority, against the Tutsi minority. And you've encountered those situations throughout world history, and they're very sad. Today, in modern day society, you can actually see something similar happening in China with a Muslim minority known as the Xinjiang. I'm very bad at pronunciation, but it's spelled, I believe, Xinghur, something along those lines, where they're also committing tremendous atrocities towards this Muslim minority group within China. Also Tibet within China as well. So that brings us to this concept of the rule of law. What is the rule of law? For those of you that have taken me in law studies, I've mentioned some of the different ways that we can make law more effective, right? And the rule of law kind of implements that concept in a little bit of a different manner than how I've taught it to you guys if you've taken me before. But the idea with the rule of law is that in order for law to be effective, in order for law to be perhaps fair, is a better way of describing it, we want to make sure that people are aware of the law, that people have public knowledge of law. There's no point in passing a law if nobody knows what that means. There's no point of passing a law if only 10% of the population is aware of what that law means, right? So those are the things that you've got to keep in mind. That's the first criteria for fulfilling the rule of law. A second criteria is making sure that law is clear. What that means is law has to be written in such a manner that people can easily understand it. Again, if we use very fancy, sophisticated language when we are passing our laws, and we don't simplify it or make it so that other people can understand it, it kind of defeats the purpose of passing these laws in the first place. And another criteria that they set here is making sure that laws are applied equally to everybody, meaning that different groups don't receive favoritism, meaning you don't give preference to certain groups over others. So those are the three criteria that they mentioned for rule of law. I've taught before 7. I'm not going to go into those 7, but I'm going to stick with what the textbook uses. But there are others. I'll mention them very quickly. Whether people follow the law with their actions, whether people agree with the law inside of them. Those are 2 separate ones. Whether the consequences for breaking the law are proportionate, meaning are they the right amount of punishment, not too much, not too little. That's a third extra criteria that you can mention for rule of law. And a last one is whether the, I'm skipping it, I'm forgetting it right now. Whether it's applied equally. If it comes to me, I'll mention it later. But those are other criteria that we can use to define what rule of law is. Uh, when in the United States we have a rule of law, okay, and what that means is we try hard to follow these criteria that I have listed. The document that creates the government of the United States is the U.S. Constitution, and it's essentially the purpose of the U.S. Constitution is to make sure that people's rights cannot be removed by the government. In other words, the role of government is to protect individuals and their rights, and that's the purpose behind the Constitution. Now, when we're talking about legal systems, there are four main legal systems that this textbook mentions today, that exist today. Again, for those of you that have taken my law studies class, I've taught you at least three of these. Okay. Um, and they mention that there's a possibility of a fifth legal system as also emerging in today's society. I really think that this chart here does a very good job of summarizing what each of these legal systems contain. I caution you because some of you get confused and describe civil law as a legal system that is what is found in the United States. In reality, no, the United States has the common law legal system. Okay, so let's get through these very quickly and try to explain what each of these does. And I'll try to give examples of countries that have these legal systems as we go over them. Common law legal system is the legal system that was invented by the British. It's very unique to the British, and that has carried over and has been extended to countries that at some point were largely occupied by the British for a prolonged period of time. So you're going to discover that common law legal systems are found in the United States, in Canada, in India in part, in Ireland, Australia, New Zealand, Bahamas. All of these countries are going to have common law in them because they were at some point largely British for long periods of time. And what sets apart common law is this concept of precedence. Okay, so the way that common law works is judges are empowered to have the ability to create outcomes in cases where the law doesn't actually specify very clearly what should happen. Judges have the ability to kind of deviate a little bit from the law and make their own law. We call that law common law. The reason that judges are empowered to do this is because judges are going to be given a little bit of flexibility to promote fair outcomes, fair results. So perhaps the law that was written out back in the day, it would have been by the king, wasn't very clear about what would happen in specific situations. And so imagine a scenario where cannibalism has taken place because the people got involved with cannibalism after 25 days of being stranded out on an ocean. Well, there was a law banning cannibalism, but the idea was not at that time when those laws banned cannibalism. We weren't trying to punish people who only had one of two options, either cannibalism or death. And so, when faced with those scenarios, judges are going to have in a common law country the flexibility to adapt the law to that specific situation and in the process make up their own law. And in the future, they're going to those decisions that judges are making with their explanations for how they reached their results. They're going to be all those decisions that the judges made are going to be written out in documents that we call opinions. These opinions are going to form the basis for how future judges who have to deal with similar cases in a common law country are going to choose to interact with a new similar case in the future. That's common law. Okay, and the idea again that future judges are going to respect what previous judges have said the law is in different circumstances. That's what we call precedent. That's what we call precedent. Um, Now, within common law countries, you're going to discover that we have an adversarial system. Adversarial system means that the judge doesn't actively get involved in a specific case, trying to ask questions, trying to interrogate witness, trying to force witness to show up to the stand. The judge's role is simply to sit back and play the role of an umpire. And as the sides argue it out and ask the judge to get involved in deciding an issue about the case, the judge will do it, but the judge will not interject themselves into that case. That is common law. Okay. Now, civil law countries, they do have juries, by the way. Many times, many of you wrote that civil law countries didn't have juries. Civil law countries do have juries. I understand the confusion looking at the textbook. But the purpose of civil law countries, what they view things a little bit differently. What they view is all their laws are written out into what we call codes, okay? With all the exceptions. Everything is always written out. And the role of the judge is simply to apply the law that has been written out in codes by a legislative body strictly to the case at hand. Judges don't have that leeway to try to create exceptions or additions to what that law was written out. The idea there is that lawmaking power is given to legislative bodies who are elected by citizens. So they're the ones who should have the final say over what a law is and the only say over what a law is, instead of a judge who many times is not elected by the people. And that's the concept why people who defend civil law think that it's more fair than common law. Of course, if you're a believer in common law, you think that results are more fair with common law because judges have the ability to adapt, which in a civil law country they do not. Okay. Now, civil law was originated in Rome. Okay, so it comes from the Roman Empire, and also in part by the French. So those are the two biggest supporters of civil law. You're going to see it in most of Europe, outside of the British and outside of Ireland. So really you're looking at Spain, France, Italy, and also Germany, and countries that came from Spain, France, Italy. So Mexico came from Spain, therefore Mexico is a civil law country. Okay, so on and so forth. Cuba came from Spain, so before Castro, Cuba would have been a civil law country. Argentina came from Spain. So Argentina is a civil law country, et cetera, et cetera, et cetera, et cetera. Their legal system is what is known as inquisitional or inquisitorial. I've heard it be pronounced both ways. And what happens under this legal system is that the judge in the middle of a trial actually gets to actually ask witnesses questions on their own and demand that one side look for more evidence and give an opinion on how a jury should decide the case before the jury decides the case. In a civil law country, judges are much more proactive in the process of the trial. The idea behind it is that they want to make sure that it's not the side with the best lawyer that wins, but rather they think that they should be involved in the process of promoting fairness. That's their way of promoting fairness. In a religious law country, okay, religious documents form the basis of legal sources. Okay. Now, this is highly controversial because, many of you are very strong believers in the concept of separation of church and state. And if your country adopts a religious legal system, well, there is no separation of church and state, or it's very highly blurred. Now, religious legal systems don't necessarily always have to apply to a government or to a country. I'll give you an example. The Catholic Church has what is known as canon law. And canon law is the legal system for procedures that have to do within internal affairs of Catholics. So if a Catholic wants to get married, the legal steps for a Catholic to get married within the Catholic Church. It doesn't mean that you can't get married in the country where you're at. It just means that if you want to have your marriage recognized within the Catholic Church, there are certain steps you have to take, and those steps are outlined by the religious legal system for Catholics that is known as canon law. But other countries do adopt very strictly legal systems as part of their own manner of governing, and you encounter that a lot within certain Muslim countries where they adopt what is known as Sharia law. Sharia law is found in Saudi Arabia, in Nigeria, in different parts, in Iran. And frequently, they supplement the country's own laws, but many times they are the main source of the country's own laws. And the source of Sharia law is from the one interpretation or an interpretation of the Quran or whatever that country's interpretation of the Quran is. And it can be very strict, very harsh, what we would define as being very harsh. So um, within Sharia law, if you're caught stealing, your hands get chopped off. If you're found committing adultery, your sexual organ gets cut off um, or burned, depending on the circumstance, whether you're a man or a woman. If you are, uh, sometimes certain consequences can be that you are stoned to death. So Sharia law can be very extreme by American standards, but that is another legal system, and that's another example of a religious law legal system. Customary law, these are legal systems where kings and queens have a lot of power and basically, or tribal leaders have a lot of power, and they have the ability to pass certain rules, certain laws, and those kings and leaders are seen to be above the law. Probably an example of customary law would have been pre-World War II Japan, where the emperor had tremendous legal power, and there was a lot of custom, the emperor was seen as a god at that point, and even though the emperor didn't necessarily make the day-to-day laws, and in many ways was not as powerful within the government as people from the outside would have perceived, they still had a lot of power, or they still had a semblance of power in certain areas, and uh, the people honored them because of custom, because of history, and this concept within Japan, because they perceived him to be a god. Okay. And then we have hybrid law. And hybrid law is a combination of two or more legal systems within a nation. You can possibly make an argument, for example, that I'll give you two examples of hybrid law legal systems. Louisiana has a lot of civil law within it, even though Louisiana, by being a state within the United States, should have common law. But Louisiana, because it came from the French, there is a lot of very strong influence within civil law influence within Louisiana. So much so that many times we consider it more civil law than common law. Perhaps another example of a hybrid law legal system would be the British, in that the British have the common law legal system mostly, like I'd say 90-95% of it, but they do have a little bit of customary law where the king and queen have some power in some way. I wouldn't say that it's fully customary, because I don't think that the queen or the royalty within England are seen to be above the law, but they do have certain powers because they're the king or queen, and they do have certain immunities, etc., by virtue of the fact that they hold the title of royalty within Britain. So that pretty much covers all of these legal systems. I don't want to review word for word, because I think I've already talked about them. I like this map because this map does a pretty good job of trying to show you some of the places in the world where there are different legal systems present. But so if you're bored, or if you are interested, you can look at this map a little bit more in depth, and you can discover how there are different legal systems in the world. The next question that I want to address is where does law come from? Why do we have laws, and how do we separate what is right from what is wrong? And if you've taken me again for a law class, I've tried explaining to you that a big source of why we have laws stems from what we would define as morality. The book mentions it a little bit differently. They describe it as social norms. But the idea is that we have within every society a series of rules that we know shouldn't be broken, even though they're not laws. I'll give you an example of a social norm in the United States. If you're in an elevator and there's only one other, and you're in an elevator and another person enters that elevator, you're supposed to spread apart to the opposite sides of that elevator and not stand right next to each other. That's a social norm, right? Like if somebody stands right next to you in an elevator and there's plenty of room within that elevator, it's very weird. We consider that creepy. It's not a law, though. I mean, if somebody does that, they're not breaking any law. They're not doing anything that's illegal or even arguably immoral. I don't think there's anything wrong morally with it, but it is something that our society has described as, without ever having phrased it, an example of a social norm that we respect an elevator space and we try to give people space within an elevator as much as we possibly can. And when we break that, it's awkward for us. We feel uncomfortable. And that's an example of a social norm. But not all social norms are laws, and that's an example of one of them. However, many of them are laws, right? This idea that we should respect the person's private property is an example of a social norm and also a law. In that if somebody tries to steal your car, well, they're breaking a social norm as well as a law. So sometimes social norms do fall within the umbrella of regular laws, but not always. Now, the book is going to define laws in a series of ways. The first type of way that they're going to describe is what is known as public law or private law. Public law is basically law that applies to everybody. So if you're breaking a public law, it applies to everybody. The law, it's fair for everyone. It's a law that a government has passed, and a government that has the authority to pass that law. So, the examples they use here in the textbook include criminal laws, constitutions, etc., administrative laws, etc. Right? Like if you commit a crime like stealing, well, there's consequences. You have broken public law. Private law, on the other hand, is specific on, it applies to individual people or individual parties. An example is a contract. A contract is a form of private law. If two people sign a contract and get into an agreement in a contract, and one of them breaks it, they are breaking what is known as private law. That's how you can sue somebody who's trying to breach or break a contract, because by signing that contract, they created a legal document that has enforcement within it. Okay. The other way that we can define law is between civil and criminal law. Now, many of you get confused here, and I need to define or create a distinction. Civil law is a term that can be used in two different ways, because it has two different meanings depending on the context in which we use it. Civil law, within the legal system context, talks about these laws that are codified or written out. And that's what we mean when we talk about civil law countries, a legal system. However, whether you are in a civil law country or in a common law country or any other type of country, they will divide their laws into two types of laws: criminal and civil. So this context, this definition of civil law in this second meaning is different from the first one. What we mean when we define laws as either being civil or criminal is that civil law usually involves an issue that two people have with one another. So usually with civil law, you're going to discover that they're having a private law issue. And so civil law is a lawsuit. Civil law is a business issue. Civil law is a divorce issue. Civil law, many times family law issue. Those are examples of subject matter of law that fall within civil law. On the other hand, criminal law involves a wrong that a person has committed to society that the government of that society has chosen to solve through punishment. And that's what we can define criminal law as being. So here you have a very nice distinction between criminal law and civil law. I recommend that you look into it. Civil law, generally speaking, can be either statutory or common law. We've talked about that. Criminal law is very rarely common law nowadays. It used to be common law, but nowadays it's more likely to be written out in statutes. In a civil law case, you're going to have an individual who starts the trial, a plaintiff, whereas in the criminal law case, you're going to have a prosecutor or the government who's going to start the case. There are going to be different burdens of proof. I don't want to get into that right now, but the obligation of winning the case is going to be larger if you are in a criminal law case and you're the state compared to in a civil law case and you are a plaintiff. The consequences for breaking a civil law and criminal law are going to be different. We are going to consider punishment if there is a crime. So you're going to see jail time, death penalty, fines, therapy, community service. Whereas usually civil law consequences have to deal with money. These are fancy words that we'll get into perhaps another day. But for the most part, the consequences making a civil law involve damages or money. And the purpose of civil law and criminal law are different. The purpose of a criminal law is to protect society, whereas the purpose of a civil law is to try and fix a wrong financially that one individual has caused another. There's a third way that we can divide law, and that is between procedural law and substantive law. Now, procedural law is the individual rights that a person has throughout the legal process, the individual rules that are a part of how the trial process or how an arrest can be done or how a case can be handled, okay? Or how you can proceed in court. All of those are examples of procedural law. On the other hand, substantive law deals with subject matter. So the actual topic of law we're talking about, whether it's a crime, whether it's a lawsuit, whether it's a whatever, all right? And they give a really nice example that defines the difference, or that helps explain the difference between substantive and procedural law. If you're driving beyond the speed limit, you're breaking the substantive law, the subject matter of speeding. However, how you can appeal your case in court and how you can argue your case in court is handled within procedural law. Okay. And then, of course, we have the different types of law, the sources of law here in the United States. You're going to discover that the biggest or the most important law in the United States is what is known as the Constitution. That is the supreme law of the country. And particularly what I mean by that is the U.S. the U.S. Constitution. So the U.S. Constitution is going to define the powers of the government. It's also going to have the restrictions of the government within it. And you're going to see, I'm going to move on from this because this is a business law class and we don't really need to focus a lot of our attention here. But this is something that you would cover more in a constitutional law class. Beneath constitutions, the next law that you're going to discover is statutes in the United States. Statutes are the laws that are passed by a legislative body. So if it's a federal law, it's going to be a federal statute. But realize that the state of Florida can also pass state statutes or state laws, and we would call those state statutes. Statutes are started by bills, which are just proposed laws. And once a bill is written, it needs to get approved by the legislative body within that region to make sure that it becomes a statute. And usually the executive branch, either in the form of the president or the governor, signs off on the bill. Now, if you notice, I told you statutes can be either state or federal law, but it's not going to be town or city law. So town or city law or county law, we call those ordinances. And they're basically the same thing as statutes, except for the fact that when you're talking about an ordinance, that's a term that is that is reserved for a town, city, or county. All right. Other forms of law that you're going to encounter are treaties. Treaties are law that's made between two countries in the form of an agreement, a written agreement. In the United States, treaties have the same power as federal statutes. And then in certain instances, you're also going to discover what are known as executive orders. Executive orders are rules that the president has made with the power that the president has received from Congress in certain areas to enforce the law. So executive orders are really rules that the president passes or the president writes to do the job that Congress has asked the president to do in a law. Executive orders kind of distinguish how the president or are an example of how the president plans on enforcing or honoring that statutory law passed by Congress. All right. And if you've taken one of my classes, you would see that we've had these before. Okay. the hierarchy of sources of law. I've done it a little bit differently. I don't need you to know that I don't need you to know how I've done it before for the test. But I recommend that you do look for this because maybe it's something that we explore a little bit later on a test or on a quiz. All right. Now, the second chapter, the court system. Okay. Uh, the way that we define our court system here in the United States, before we get to that, we have to divide the branches of government. And we know that we have an executive branch, we know we have a legislative branch, and we know we have a judicial branch. Okay. And these different branches have different powers within them. Now, specifically, what I want to look at in this chapter is the court system that we have, 2.4. That's really what I want to focus in on, because that is something that does affect, that is important for business law, that is important for businesses. I want you to be familiar that there is a particular state system for courts and there is a particular federal system for courts. So if you're in a situation where you want to start a lawsuit, okay, because you want to sue somebody, you first have to discover whether you are suing the person under state law or you are suing the person under federal law. And from there, you will know which court system to get into. Now, the state and the federal, both types of government have trial courts, which is where you have a jury and you try to figure out the facts of the case and there's an outcome, right? If it's criminal trial, it's going to be guilty, not guilty. If it's a civil trial, it's going to be liable or not liable. On the other hand, appellate courts are going to be reviewing trial court decisions and issues within trial court, particularly on procedural law, to see, because one side is claiming that in the process of that trial, a wrong took place from a legal standpoint. And so an appellate court is trying to review the process of how that trial was conducted to see whether any law was broken. And if it was broken, they would many times ask for a new trial. The appellate court would demand a new trial. All right. So there's a nice map of how these trial courts may work. At the federal level, you have U.S. district courts, which are the trial courts. There are 94 of them. There are appeals from there to the U.S. Circuit Courts of Appeal, which are the first appellate court that you have in the United States. And those are the 13 circuit courts that we have. Florida belongs to the 11th. And from there, if there was an appeal here, you would go all the way to the Supreme Court of the United States. However, you have a guarantee shot of sending a document here of the U.S. Court to the U.S. Court of Appeal and being heard by them or receiving a message back from them. The U.S. Supreme Court, the U.S. Supreme Court, if you appeal to them because you lost here at the U.S. Circuit Court level, they may just leave you unread, as you guys like to say, and not respond to your appeal. Just not even reply to you. And if they don't reply to you, whatever the outcome that happened here is what's going to happen for the case. So there's a nice map of the U.S. Courts of Appeal and the district courts. And I really want you to focus in on understanding what this is, what the difference between trial court and appellate court is. The trial court is going to try to figure out what the facts were on the case. So we're going to try to figure out what happened, why it happened, and whether somebody broke the law or not. And if somebody did break the law, what the consequences are for having broken that law, whether it's a civil case or it's a criminal case. On appeal, we're asking different questions. Was the process fair? Did the trial court make a legal mistake? Did the trial court apply the correct law? And so I really want you to understand these two different types of courts and understand that they exist within the state and federal system. In the state of Florida, we would have the county and circuit courts serve as our trial courts. Our appellate courts, our first appellate courts would be called district courts of appeal. In Florida, there are 5 of them. Miami belongs to the 3rd one. And then there is a Florida Supreme Court at the top of the court system. And that's a very similar pyramid to what we talked about here within the U.S. system, where we have the trial courts that are the U.S. district courts. And then from there, we have the 13 Circuit Courts of Appeal, and lastly, the U.S. Supreme Court. And that is pretty much it for this chapter. That's it for the lecture. I look forward to seeing you guys continue doing your assignments. And stay safe, everybody. See you in a week. Bye.